My name is David Oldroyd-Bolt. It's my pleasure to be your host for the next 2 days. I'm a visiting fellow here at the Danube Institute, and my particular focus, therefore I will not be speaking, is British conservatism, a thing that is probably even more hopeless than the rule of law at the moment. I'd like to begin by asking my colleague, the Executive Director of the Danube Institute, István, to begin today's proceedings with a note from the Danube Institute. István.
Thank you, David. Good morning, dear ladies and gentlemen, dear Minister, Your Excellencies. It's a great pleasure to welcome you here this morning in our beautiful building. And also, I'm kind of cautious of the very early start, so I'm very grateful that so many people turned out despite the early beginning of this conference. So I only want to speak a couple of things here, really. Growing up in post-communist Hungary, we always saw rule of law, human rights as kind of sacred cows, as things which are kind of given, you have to follow them, it's rules which you cannot deviate from. Of course, quite early on, because I'm also a dual British-Hungarian citizen, I realized that the British political system is very unique and very distinct to what was going on in Hungary. To name one few thing, the separation of powers is not really existent in the British system, and still it seems that they produce much more better outcomes than most European countries which might have this separation of powers. So quite early on I realized that nothing is actually as it seems, and I remember I was kind of disillusioned by some of the reforms going on in the 2000s under Tony Blair, the so-called constitutional reforms, where I think they basically throw out hundreds of years of constitutional developments in the UK for a more progressive ideas. And I remember I was kind of feeling strange that how is this possible? Why am I doing this? And this was kind of the first moment I realized that perhaps the left has this tendency to take over institutions, take over what we consider sacred ideas and basically use it and turn them against conservative principles. Another kind of feeling like this happened in 2015 when the US Supreme Court voted to legislate same-sex marriage. This happened despite the fact that in several states, perhaps one of the most famous case was California, which cannot really be seen as a very conservative state. They had referendums where they actually voted against the legalization of same-sex marriage. One of that happened in 2008. So I was thinking, should really kind of Supreme Courts, which are not elected bodies, make decisions like that, which affect the lives of so many people? Shouldn't we have normal political debate? And I was already kind of, because of this fascination with the British system, I already was kind of fascinated with the idea of parliamentary sovereignty and also political constitutionalism. I know there's a lot of lawyers here, a lot of constitutional justices as well, and I don't want to offend them, so I will not talk a lot about kind of the idea of political constitutionalism, but I think the British system was in this sense very interesting and very close to my heart, and I still kind of tend to believe that debates based on values, on everyday life should be mostly made by the people themselves, by democratically elected legislatures, and not by courts which aren't elected by anybody. Of course, in recent years, we have been seeing much more troubling tendencies. Just the past year, we see what was happening in Israel. We saw very troubling tendencies going on in Spain, and of course, much more closer, and I'm very grateful that we have actually people from all these three countries, but much more closer, Poland, where basically, with a simple majority now, the Polish government is rewriting rules, basically doing things which usually they accuse right-wing governments of doing. But of course, if they are doing it, then it's less of a problem. So the past 1 year, I think, showed a lot of troubling tendencies, at least in these three countries. I'm very grateful that we have speakers from all of these countries, and I'm very much looking forward to these discussions with them. And actually, kind of the idea of this conference, I think, sprang out of these troubling tendencies. I remember talking with Ofer Hivri, who I want to thank here, because I think this conference wouldn't happen without his idea and his support. So please give him a warm applause. Ofer has been a visiting fellow with us now for, I think, almost 2 years. It was his idea that we should do something. We already have kind of a workshop on conservatism which has been ongoing, but we thought that because of these tendencies, it would be very important and good to set up a kind of a task force of European and, of course, global conservatives to talk on issues relating the rule of law and basically lawfare. And out of this idea, we actually organized a smaller conference in Brussels, which actually was very much thanks to Mario Fantini, who's here as well. I want to give him also warm applause. They really took a huge chunk there and helped us do that conference in Brussels. And from that conference, we wanted to do a much bigger thing, have much more international speakers here in Hungary, which, as it seems, sadly, is much more safer to do conferences like this than Brussels, as sadly NetCon has showed in April. So the idea was to get together, talk about these issues, because the left has been doing this for centuries. I'm excavating it, but at least for 120 years. And it's not new. I mean, I'm firmly believing that if you would have had a Democrat president, then Watergate wouldn't have happened, or they wouldn't have destroyed a Democratic president like they did with Nixon. They tried to do the same with Reagan during the Irangate. They tried to do the same with Bush. We can see what they're doing now with President Trump. So they have been doing this for at least decades, and we haven't really realized. And I think we need conferences like this, where we come together, talk about these troubling tendencies, see that what is happening in Poland can happen in Hungary if there's a left-wing coalition coming in. What is happening with President Trump can happen to other democratically elected presidents across the world. What is happening in Israel can happen to other conservative governments across Europe. So I think it's very important to have these discussions, and I'm very grateful to our co-organizers. Already mentioned some of them. One is the Center for Fundamental Rights. Give a shout out, and also Attila, who was very much involved in. I will come to István as well, who will speak after me. But now on the organizational side, I have to thank Attila here as well. And then, of course, the European Conservative, which also has been a wonderful partner in this conference. I already thanked Mario, so I want to thank Ellen here as well, his lovely wife. Give a quick shout out. So thank you for being here. I don't want to keep your time. I think the minister will have to take his leave soon. So I will give the floor now to István Kovács, the Secretary Director of the Center for Fundamental Rights, to make his speech.
Thank you, István. Dear ladies and gentlemen, dear Minister, distinguished excellencies, international guests, for me, it is the most obvious way to start a conference as addressing dear ladies and gentlemen, while in the eye of many, this is already the infringing of rule of law. And for those complaining for lacking any other sexist, genders, or whatever, I would like to emphasize that this is Hungary, a country for no woke men, and the Hungarian fundamental law recognizes only male and female. And now you've already understood that it is a bit strange for some eyes that it is indeed Budapest where such a prestigious conference dedicated to the topic of rule of law takes place. But in my opinion, nowadays you can hardly find any better place to such a conference, because within the past years, due to the set of all the different blamings, criticism, and legal procedures against Hungary in the name of rule of law, proved to be like a symbol of how to weaponizing the rule of law. And I know we have many Israeli contributors today, shalom my friend, but I would like to inform you that pursuant to the declaration of the European Parliament, the one launched the Article 7 procedure against Hungary. So according to the very document, the life and the fortune meaning the assets of the Jewish population in Hungary is under continuous threat by the actions taken by the government. On the other hand, we see pro-Hamas protests all across the big European cities and in US campuses as well. But these are, of course, totally in line with all the criteria of rule of law. And I think this is a clear evidence of double standards. And this is said because in its genuine form, the rule of law means nothing more than all the citizens and institutions or members within a community are accountable to the same laws adopted by the entitled bodies in a legitimate lawmaking procedure. And I know I am oversimplifying things, and I'm sorry for it. This is only because of lack of time. But according to this definition, using double standards in any legal procedure, by its nature, it's against rule of law. But we see many, many examples today for using double standards. István already mentioned Poland, and for years it was not only Hungary but also Poland against which the Article 7 procedure has been ongoing for years, but not ever since Donald Tusk entered the government and started to restore rule of law. And it took only by imprisoning some acting members of the parliament, invading and occupying the public media. It took only to raid the house of a governmental official suffering of late-stage cancer, so bonded to bed, literally, and they raided his home for a whole day. And when Donald Tusk was asked for some justification, he said that we will find the legal basis. Unfortunately, he said it like a couple of days after all the tragic events took place. So these are good examples for the double standards are being used in the name of rule of law. And another good example is, of course, Hungary and the showcase trial against Hungary, which is, in my interpretation, nothing more than a political witch hunt. So the Article 7 procedure against Hungary were launched in 2018 by the European Parliament. I already quoted from the report. It's called the Sargentini report, and have been ongoing ever since. In adopting this totally falsified report, the EU even broke its own bylaws to get the necessary majority. And another step forward in this procedure was the introduction of the rule of law conditionality procedure, ended up with freezing a lot of EU funds lawfully belongs to the Hungarian people. And Ursula von der Leyen, the head of the Commission, later said that Hungary could only get this money if it changes its migration and family policies. In doing so, she openly admitted that the rule of law is nothing more than a tool of blackmailing the Hungarian lawmakers. As von der Leyen admitted, Hungary is under continuous attack for not accepting liberal dogmas on migration and gender, but unfortunately, since then, the pressure seems to have been extended to another issue, the war in Ukraine. And you all know that Hungary is the only government stood up for peace, immediate ceasefire, and peace talks since the very beginning of the war. And nowadays, the European Union tries to blackmail Hungary into the war against the will of the Hungarian people, against the Hungarian parliament and the government. So we are living in a world when the European Union once started as a project of peace. So the liberal elite, nowadays leading the European Parliament, already started to reorchestrate the project into a project of war. And I might say that we must stop this madness. And of course, we must stop it by elections. So you know the European elections are coming, and later this year, elections in the US will take place. So first of all, we must stop this madness by these elections. However, and I came to the conclusion of my short speech that politicians will always need background materials, argumentation. And in my interpretation, the main purpose of such a conference is to provide such material which can stop the madness. So I wish you a very good stay, pleasant stay in Budapest, and a productive conference in this spirit. And now the only duty I have left with is calling to the stage Mr. Mario Fantini. He already got a big applause, but please do it once more. He's the editor-in-chief of the European Conservative. So Mario, the floor is yours. Thank you.
Hi, good morning, ladies and gentlemen, excellencies, esteemed guests. I've been given 5 minutes to say a few words, but as a half Italian, I find it genetically impossible, usually. So I'm going to guide myself with these prepared comments. Otherwise, we'll be here all morning. I should say I feel rather like an interloper among all of you. Unlike many of you, I've never studied the law, nor have I practiced it. Though I have spent several years in Washington in well-remunerated misery at a corporate law firm, but that doesn't really count. Instead, my bailiwick is media, public relations, strategic communications, and thus words, the words we use. That is, the basic elements of the language we use to communicate. These are my obsessions. This is no surprise, of course. As the editor of what I think is the only pan-European English language publication on the right, I spend my days and sometimes nights pondering the meaning of words and what exactly a particular submission is trying to say. So words matter to me. So for the past few weeks, in anticipation of today and tomorrow, and these 5 minutes that I've been given, I've been thinking about that word lawfare, that terribly apt expression that many of us are now using to describe the unjust and malicious use of legal concepts and mechanisms to censor, sanction, and punish dissenters and opponents. Now, it's not like there's a dearth of examples. We've just heard a few. The lawfare waged against Hungary, this proud and courageous country. The lawfare waged against a former U.S. president by what I call a host of unsavory characters within the Democrat Party. And most recently, I was reading a report out of an environmental unit at Stanford University that said, quote, "Waging lawfare is the only way to save the planet." Now, I'm not really about to delve into the meaning and etymology of the word lawfare in these few minutes that I have, but I think this will naturally come up in the course of today and tomorrow. And I think that's something we should all look forward to very, very much. The other term that obviously will come up is the rule of law. And I'm fascinated by this term, but truly, in Spanish, actually, is where I'm really fascinated by how the term they use for rule of law. They tend to use el imperio de la ley. It's beautiful. The empire of the law. Quite magnificent. El imperio de la ley, the empire of the law, betokens a large, intricate, sophisticated construct. It suggests precisely what the rule of law would produce: a noble edifice of just laws that reflect political order and right reason. I would argue that when we speak of the rule of law, of an empire rather, whether concrete and material of the kind that in former days gave us outposts of civilization across the world, or conceptual empires of the kind I'm speaking of and about which we will speak today and tomorrow, we're always necessarily referring to the consequences of and the cultivation of various conditions, and one of these is political order. In other words, the rule of law the empire of the law, can only ever be the result of order in the polity. And order in the polity, of course, depends on order in the soul, what Russell Kirk called the first need of all. It's as simple as that. So what is order in the soul? It's the faithful adherence to those things that lie outside and above us: norms, mores, rules, truth. Only through fidelity to these can political order, the rule of law, civilization thrive. And as the Epistle to the Romans tells us, quote, the work of the law is already written on our hearts. So by extension, how can you ensure the rule of law if people, rulers, lawmakers, legislators, those ruled, are duplicitous, deceitful, and malicious? I'll leave that as an open question. Getting to my conclusion, I personally hope these and other interesting philosophical questions will arise in the course of these 2 days. But I'll now conclude with this statement. The rule of law depends fundamentally on men and women of virtue. And even though the presentations and discussions over these 2 days will likely focus on the more technical, legislative, political aspects of the meaning of the rule of law and the use of rule of law concepts and arguments, it is my job as editor of a journal whose mission it is to remind people of the philosophical arguments underpinning the legislative, political, and policy battles of today, to make sure we're all very clear that everything we will be talking about is rooted in and stems from fundamental philosophical and theological questions that get to the heart of what really is. Finally, as one scholar has written, quote, the empire of the law, or its synonym, the rule of law, is anthropocentric. It recognizes the human being as the center of law and emphasizes that the ultimate purpose of law is to protect and promote the human being. Without that very basic understanding, all our chatter will be disconnected from what is truly real. Remember that. Again, thank you all for coming and for suffering through my short 5 minutes. Thank you.
Well, thank you, István and Mario, for those words. It is now my great pleasure to introduce our two opening keynote speakers, beginning with Minister János Bóka. Dr. Bóka is the Hungarian Minister for European Affairs, and he will begin, followed by Professor Hadliakis, who's a most distinguished lecturer in and teacher of law, and I'm sure you are all familiar with his work, particularly his many books on the subject. So I'd like to begin by asking Dr. Bóka to begin this keynote.
Dear colleagues, ladies and gentlemen, I commend the Danube Institute for the excellent initiative to organize a conference of rule of law as lawfare. The topic is crucial, the timing is appropriate, the invited experts are competent and respected, and the venue is one of the best you can find in the city, or the continent for that matter. And most importantly, you don't have to worry about authorities banning the event or the police stopping you from entering. As a matter of fact, there is a competing event scheduled for today, organized by the Central European University Democracy Institute. You know, this is the higher education institution that left Hungary without actually leaving, a launch event for its rule of law clinic. The speaker is the Polish Minister of Justice, Mr. Adam Bodnar, who will address, I quote, the legal and political challenges in rebuilding the rule of law in Poland. Of course, he's selling the product of how to make constitutional changes without a constitutional majority, but that's beyond the issue here. The point I'm trying to make is that Budapest is one of the few cities in Europe where these two events can actually take place in parallel, where ideas and interpretations can actually compete. I think we should pause for a minute here and grasp the significance of this freedom and the importance of safeguarding this freedom for the next generation, because we cannot take this for granted. But this coincidence also prompted me to reconsider the tone and content of my keynote speech today, because ideas are competing. I think time has come to speak with full clarity about rule of law as a political concept in the European Union, its origins, content, objectives, agents, and mechanisms, and then with full clarity about rule of law as a legal concept that could and should be applied in the European Union, and then with full clarity about the fact that these two issues are completely unrelated. It's a different journey, but bear with me. Article 2 of the Treaty on European Union states that the EU is founded on certain values, including respect for the rule of law, and that these values are common to the member states. The treaties do not contain a definition of rule of law or any reference to any sources where this definition is to be found. Then Article 7 in the same treaty outlines two procedures: a preventive arm for cases where there is a clear risk of a serious breach, and a sanctioning arm for cases where there is a serious and persistent breach. These procedures are purely political by design. There are no legal benchmark or criteria, and there is no involvement of the Court of Justice of the EU. Some historical background is also necessary to understand the true meaning of this mechanism. The preventive arm was introduced by the Nice Treaty in 2001, when political sanctions against Austria for forming a government with the participation of FPÖ backfired. At that time, these political sanctions were outside the scope of the treaties and had nothing to do with the rule of law situation in Austria. They simply sent the message that certain political parties, certain policies, statements are not tolerated in the EU, regardless of the democratic decision-making processes in member states. The conclusion at that time was not that such political sanctions should be discontinued. Exactly the opposite. The conclusion was that they should be transformed into regulated procedures and should be included in the treaties. But the political intentions remained the same. In this context, it is important to properly understand recent legal and institutional developments, including the annual rule of law reports by the Commission, the rule of law dialogue in the Council, the general budgetary conditionality, the horizontal enabling conditions for cohesion funds, the so-called super milestones in the recovery and resilience plans, and last but not least, the constantly developing jurisprudence of the Court of Justice on the EU becoming a community of values and EU law becoming a set of values instead of a set of rules. These developments are not aimed at changing the nature or objective of the rule of law instruments. The interventions remain purely political in nature, and their objective remains to discredit certain political forces, to coerce them into changing their key policies, and ultimately remove them from power, if necessary. These developments are aimed at making the available tools more effective. First, they try to mask the purely political nature of these tools by creating a procedure with a semblance to applying to all member states and being based on objective criteria. Second, they establish additional coercive measures that are easier to adopt and now include access to certain EU funds. This, of course, required the European Parliament, the Commission, the Court of Justice, and key member states to play along, which they were happy to do for very diverse reasons. And most member states remained silent because they thought they were never going to be affected or simply feared retaliation. As a result, now we have an annual rule of law report by the Commission that focuses on 4 areas: the judicial system, the anti-corruption system in member states, media pluralism and media freedom, and other institutional aspects related to checks and balances that include a wide variety of issues from NGO environment to the transparency of the legislative procedures. It goes without saying that these areas do not reflect any structured concept of the rule of law and are determined by political convenience. The country chapters of the reports now include recommendations that are non-binding, but are cross-referenced in the European semester process in the country-specific recommendations that in turn form the basis of member states' recovery and resilience plans that need to be implemented in order to access RRF funds. Member States discuss the country chapters of these reports in the so-called rule of law dialogue in the Council. That is a totally meaningless ritual with only one objective: to show that the EU deals with the rule of law situation in all member states, not just a few ones selected for political reasons. In the beginning, we tried to raise issues of serious concern in other member states and highlight inconsistencies and double standards in the approach taken by the Commission vis-à-vis different member states. We were, of course, rebuked and told that we misunderstood the point of the exercise. They were right. We indeed misunderstood the point, which was to legitimize political pressuring of certain member states on the pretext of rule of law concerns. The Commission's rule of law reports are also part of the attempt to provide an objective and legalistic, and I deliberately don't use the term legal, cover for a fundamentally political process. In this exercise, the Commission is enormously assisted by NGOs, financed by the Commission itself, and the Court of Justice. In particular, the Court has started to develop a jurisprudence on the content of rule of law in preliminary ruling and infringement procedures concerning the judiciaries. For our purposes, the meaning of this exercise is twofold. First, to give the impression that rule of law is a properly defined legal concept that can serve as the basis of not only political but legal proceedings. And second, to indicate that the monopoly of interpretation of rule of law now belongs to the court, and national institutions, including constitutional courts, must align or risk being circumvented by regular courts, having direct recourse to and authorization from the Court of Justice in Luxembourg. This is, of course, part of a wider political agenda pursued by the court, namely to turn EU law from a body of rules into a body of values and standards. Supposedly, it has to do something with the fact that the EU is not only a community of law, but also a community of values. I strongly believe the European Union to be a community of values, not only and not primarily because the text of the treaties is open to such interpretation, but because it is a fact. However, I think that the argument that if the EU is a community of values, then EU law must be transformed into a body of values, and consequently EU institutions, including the Court of Justice, will become the designated venue for value disputes, is not convincingly made. But I am afraid I must leave this extremely important issue aside here, because it is well beyond the scope of my keynote speech. So the mission is accomplished to mask the purely political nature of the rule of law related procedures by creating a semblance that they apply to all member states and are based on objective criteria. Now we come to the part of establishing additional coercive measures that are easier to adopt and include access to certain EU funds. Of course, you can cut access to EU funds under Article 7 as well, but this is seen by all as a political decision, and in addition requires a previous unanimous decision in the European Council, which is close to impossible to get. For additional coercive measures, you need a legal base in the treaties, which allows qualified majority decision-making, and you need to be able to explain that the procedure you created is not simply a duplication of the Article 7 procedure. The first part is easy, especially if the Court of Justice is on your side, which is granted in this case because it perfectly fits into its agenda of redefining EU law as a body of values. The Court ruled that a general budgetary conditionality that allows suspension of EU funds in the case of rule of law-related concerns is, I quote, a financial rule which determines in particular the procedure to be adopted for establishing and implementing the budget and for presenting and auditing accounts, end of quote, and therefore falls under the scope of Article 322 of the Treaty on the Functioning of the European Union. The second part is more difficult because here you need to prove that a rule of law related concern that has an impact on the financial interests of the EU is not really a rule of law related concern anymore, but a financial one. And then you need to completely dilute the concept of financial impact to a level where no actual impact is needed, but an indirect risk is already enough to establish a connection. If you manage to do that, then you will end up with a procedure that protects the financial interests of the EU from rule of law related concerns, even if there is no actual impact on the financial interests of the EU. So the only thing you actually have is a rule of law related concern. Nevertheless, this is not a rule of law related procedure, because if it were, it would be a duplication of Article 7, which is against the treaties. If you can't follow, don't blame yourself. So, as a result, we now have two types of rule of law related procedures. There are those that are openly and exclusively political in nature. Article 7 procedure is an example of that. If I look at the history of how they were started and how is it about to be closed in the case of Poland, and how Hungary was threatened with the suspension of our voting rights if we don't agree to certain decisions concerning Ukraine in December last year and February this year, I believe no further explanation is needed. As regards Article 7, there is no need to discuss standards, rules, or benchmarks. It is hardcore politics and must be treated as such. Then, there are procedures that are political procedures with a legal mask. For example, the conditionality procedure. This is a more complex story, where you are expected to engage with the Commission exactly the same way you play chess with a pigeon. Now, don't get me wrong, I don't mean this in a derogatory sense, because I think that neither pigeons nor the Commission is stupid. Chess is a sophisticated game with strict rules. When you play chess, you challenge your opponent with the objective to prevail within a framework of rules and assume that your opponent wants to do the same. Now, when you play with a pigeon, it will also move the pieces on the board, sometimes even according to the rules. It very rarely wins, but it couldn't care less. Obviously has a good time and keeps you occupied for quite a while. And at some point, the pigeon decides it had enough and flies away. You might think this is because you won the game and the pigeon gave up. But don't forget that the pigeon doesn't know a thing about chess. So how could it know whether it is winning or losing? So the reason for the pigeon to stay and play on, or leave and give you a break, must be found beyond the game of chess. In the conditionality procedure, the Commission's approach is very similar. It wants you to engage in an activity where the Commission can bend the rules so it can place pieces on the board the way it wants, and there is not much you can do about it. The point is not to win the game, but for the Commission and the Member State to pretend that you are engaged in a meaningful activity. That is an objective and rules-based procedure that will go on as long as the Commission so desires. At some point, the Commission might decide to end this activity, but this decision has very little to do with the actual situation on the chessboard. It is related to its political agenda. And to push this metaphor to the extreme, we are playing not one, but at least 4 such games in parallel. And in this simultaneous display, the Commission can maximize its leverage by connecting the different games. This is a very disillusioned, almost cynical picture that I painted for you. Indeed, I believe that EU procedures designed to enforce rule of law standards on member states are political tools. They are used in a tactical sense to coerce political concessions or changes from non-compliant member states. And they are used in a strategic sense to advance the federalist project by sidelining national constitutional institutions and claim the monopoly of interpreting and enforcing values that are supposed to be common in member states. Of course, these processes could be improved. A real constitutional dialogue could make the content of rule of law less contested. A better use of the comparative method and more involvement of member state authorities could reduce the chance for obvious misinterpretation and misunderstanding of national legal institutions. It does not change the political nature and the tactical and strategic objectives of the rule of law instruments. It's a lipstick on a pig. But in fact, that pig doesn't even want lipstick. It doesn't need it because obviously it is considered attractive enough without it. And any refinement or constraint of the rule of law procedures would make them less efficient from a political point of view. I am closing my remarks by emphasizing that regardless of my skepticism concerning existing rule of law instruments, I firmly believe the EU is in dire need of a rule of law instrument, but this instrument should be turned upside down. It should guarantee that the principle of rule of law, developed and applied in member states, is similarly implemented in the activities of EU institutions. Most importantly, it should include mechanisms that properly limit the EU's activities to the conferred competencies. But this is not possible by adjusting or improving existing instruments. A completely new approach is needed. This new approach requires treaty change, which in turn requires a strong political support. To build this political support, we must first survive. To survive, we need to mitigate the harmful effects of the EU's lawfare against us. That requires playing chess with a pigeon. But on the other hand, we must not legitimize the process by accepting the legal and procedural masking of a political exercise. That would require chasing away the pigeon and turning over the chessboard. To be honest with you, I am not quite sure how to do the two things at the same time. But I hope today's and tomorrow's conference will bring us closer to the solution. With this in mind, I wish you an interesting and meaningful exchange of views. Thank you very much.
Thank you, Minister, for that most enlivening and engaging speech. Now, Professor, I'd like to ask you to take the stand and give us your thoughts before we have the first panel. Thank you.
I could happily have extended the remarks of the Minister. Perhaps I could waive my own if we have time for it. A few years ago, I was invited to a meeting of giving awards, and one of the awardees remarked, he told his wife, "Darling, did you ever imagine in your wildest dreams that I could be getting an award of this kind?" She said, "Darling, I don't know how to convey this to you, but you're not in my wildest dreams." Well, I'm sure I'm not in yours, but I'm grateful for the opportunity to be here. On lawfare as warfare, I'm against it. But I was invited to speak today about the rule of law. I'm happy to see him keep going on. It was a remarkable talk. I was asked to speak about the rule of law, but I may have to use an old device of mine and compress this talk Hebraically by omitting the vowels. On the rule of law, G.K. Chesterton said that animals have no religious sense. When was the last time you heard of a cow giving up grass on Fridays? Thomas Reid pointed out that animals have no moral sense. They cannot plight their veracity, make a promise, be held accountable. Only one kind of creature is able to make a promise, undertake a commitment, and respect that commitment even when it runs counter to his own interests. In the same way, only one kind of creature can frame propositions that could be understood by other rational creatures and command respect as propositions that could be binding as law. So as Aristotle taught us, the defining mark of the polis, the political order, is law, the capacity to make decisions that are binding on everyone who comes within the territory. And that state of affairs sprang from the nature of only one kind of creature. And so anyone who's outside the law, anyone who's beyond the restraint and teaching of the law, was either subhuman or superhuman. As Aristotle said, it must be a beast or a god. Over the years, I've asked lawyers the question, why do we have law? What's the rationale and purpose of the law? And the answers usually move along two lines, that we need law for the sake of protecting our lives and our property, and for the sake of facilitating the kind of exchange that can soften the hard edges of life and lift the standard of living. And it usually comes as a surprise to lawyers to discover that Aristotle anticipated both those explanations 2,300 years ago and refuted them. The argument is that's what you think you're having law. Guess what? You don't need law for either one of them. His telling example is that of the Etruscans and the Carthaginians. They're both able to accomplish both of those purposes without becoming part of the same polity. They did it through the device called treaties. Treaties for mutual defense and treaties to facilitate trade. Now, if a political community was mainly an alliance for mutual protection and for facilitating trade, well, that can be accomplished through the domestic equivalent of treaties, namely contracts. For like treaties, they bind only the parties to the agreement, and they bind them only as the agreement marks the convergence of the interests of the parties. I'm willing to purchase the car that the dealer has for sale, and most of our lives are conducted in this way. We make private contracts to decide which cars or which schools. But then what was the problem with this? What did Aristotle mean when he warned of law sinking into the condition of being a mere contract? What was missing, he said? That neither of the parties concerns itself to ensure a proper quality or character among the members. Neither of them seeks to ensure that the others are freed from injustice or from any form of vice. In my relations with the dealer who sold me the car, my concern is that I've received the product I've paid for. But for all I know, this dealer discriminates against his other customers on the basis of race. He's an abusive father and husband. Now, I might raise those kinds of questions to him, but not as a party to the contract, but as a citizen having the power to make laws over matters of that kind. Nothing in my standing as a contracting party gave me the standing to raise those kinds of moral questions in the same way that we were told years ago. Just because we have these treaties with the Soviet Union of arms control and facilitating trade, nothing in those treaties gave us the moral standing to demand changes in the moral character of the Soviet regime, demanding they allow the Jewish subjects to emigrate and demanded that people should have free elections. Aristotle imagined a dense community of 10,000 people, thick in social relations, marriage between families, a thriving economy, perhaps a vibrant nightlife in cafes. And yet, if the relations never rose beyond the making of private contracts, of buying and selling, they would still not form a polis or political order. Now, how can that be? I found this way of putting the matter to my own students. I drew upon a scene I described years ago in my book, The Philosopher of the City. I was drawing about a show going on at Capitol Hill one day in May 1977 with Dr. Judith Denson-Gerber, an expert in abuse of children, testifying on the Hill and offering vivid examples of gonorrhea of the throat of a year-and-a-half-old girl and a 9-month-old baby. And the question was, if we're confronting things of that kind, what do we say? This is a matter of private affair for the man and his family. If we react to this as a community, what might we say? What would we say if we said, we'll offer him a tax deduction to induce him to stop? Offer him a Netflix subscription. That used to induce laughter because people could see what was widely inappropriate. The most natural reaction to that is to say, stop. It's the voice of command. Who should stop? He should stop, or anyone doing the same thing. In other words, we find ourselves backing into the logic of a moral response. We cast the argument in universal terms. Not that we don't like what he's doing, but that it would be wrong for anyone to do. We back into the recognition that when we move to the level of a moral judgment, we're moving radically away from statements of merely personal taste or private feeling. We begin to speak about the things that are more generally or universally right or wrong, just or unjust, for you as well as for me. What Aristotle was telling us, if you found a community where no one was moved to sound that voice of outrage or moral condemnation, there was something missing in the bones of those people, something not quite human there. But here was the classic connection between the logic of morals and the logic of law. John Stuart Mill said that we stop using the language of like and dislike, begin using the language of right and wrong. We think people may be rightly punished for what they're doing. So if we come to the judgment that it's wrong for parents to torture their children or sexually abuse them, the logic of that recognition is that we remove those acts from the domain of personal choice and forbid them for anyone to do. We forbid it then with the force of law. Hence, that original classic connection between the logic of morals and the logic of law. So the argument, therefore, what is a political order? Well, it's more than an alliance to protect lives and property, though that is part of its concern, to protect people from the unjustified taking of their lives and property. But the polity reaches these things because it is most essentially, as Aristotle understood, a moral association. It's a community of people who care about the terms of principle on which they live together. They share some understanding, even roughly, about the things they regard as right or wrong, just or unjust, and they take it as a chief concern of theirs to firm up that understanding among their own people about what we share about the things that are right or wrong, just or unjust. Well, then how does the polity do that? The answer was, it teaches through the laws. So when we have in the United States a law, that Civil Rights Act, that forbids this racial discrimination in private businesses open to transactions with the public, what they're saying is, we're taking that act and removing it from the domain of personal choice and private freedom and treating it as a matter of public obligation. If you take a look at the surveys, you find that 3 years, just before that Civil Rights Act was passed, there's a division between the sections. 75% of people in the North favor that law to bar that racial discrimination. 75 people in the South opposed it, coming down the side of privacy. 3 years later, after that law was passed, the majorities in favor were parallel in both North and South. What had happened? Had there been a remarkable transformation of the culture of the South in those years? Or did it have something to do with the fact that people at the top of the state were teaching some dramatic new lessons and teaching them through the force of law? But it's worth reminding ourselves that this logic was made known to us long ago, long before Aristotle, and it can be found most tellingly in a familiar story in the Bible, in 2 Samuel, that my students used to know. It's the story of David and Bathsheba and Nathan. You may recall that David was quite drawn to Bathsheba. He put her husband Uriah in harm's way so he'd be killed in battle, and David would have access to her. And Nathan came and he offered this story. He said, there were two men in the city, one rich, one poor. The rich man had received flocks and herds. And there came a traveler unto them. And the rich man spared to take of his own holdings. And he took, rather, the one little ewe lamb held by the poor man. On hearing the story, David's anger was greatly kindled. And he said, as the Lord liveth, the man who did that deserves to die. And Nathan's response was, you're the man. You're the one. Now, we used to raise the question to the students, why did he do it this way? He cast the matter in impersonal terms. That is, with that move, he brought into play the logic of moral judgment. He was trying to describe the nature of, for whom was it wrong to do such a thing? Anyone, everyone. So David drew him in to acknowledge that he would call that act wrong regardless of who did it, and that someone is you. I used to raise this matter with my students years ago just to point out that the logic was there long before analytic philosophers in England had the wit to start pointing up that logic of morals, and had another utility for me in dealing with that one student of mine who suggests that the logic of morals was something I invented in the 1960s for the sake of ruining his weekends in the 70s. The logic has been there since the beginning of our law. And it's strange that people trained in the law have not noticed that moral logic at work in the separation of powers. Separation of powers is usually celebrated as a way of putting limits on the power for the sake of safeguarding freedom. But what's been persistently and curiously missed is the moral dimension of the problem, brought out by John Locke in the second treatise, where he said, in well-ordered commonwealths, the legislative power is put in the hands of diverse persons who have, by themselves or with others, a power to make laws, which, when they are done, being separated again, they are themselves subject to the laws they have made, which is a new and dear tie upon them to make sure they make them for the public good. To put it another way, the structure of the separation of powers works to impart this caution to lawmakers. You better be careful that the laws you frame will not be given to you the authority to enforce those laws yourself. That power will be put in hands other than your own, perhaps of people unfriendly to you. So you would better not set down laws for others that you would not see willingly enforced forcefully against yourself. Which is to say that the logic of the separation of powers was to render operational the categorical imperative. Do not lay down for others what you would not see being forced to yourself as well. But that's precisely the logic that's disrupted when legislators evaded that central discipline of marking off the nature of the wrong in impersonal terms and simply stipulate the names of the people they would punish. We call those things bills of attainder. So one notable example, in the 1940s, Congress stipulated that no money shall be appropriated to pay the salaries of Robert Morse Lovett, Goodwin Watson, and others, but to name Lovett and the others is not to reveal the nature of the wrong for which they are found deserving of punishment. At times, we could list names. You could readily name the category. If I give you the names, well, Americans would get this. I gave you the names Joe DiMaggio and Arthur Miller. What would be the category? Okay. Now if I say Joe DiMaggio, Arthur Miller, and John F. Kennedy, I've altered the category. All right? Now if I said to you Frank Sinatra and Alexander Hamilton, it would be born or dying in Hoboken, and being carried there after he was shot in Weehawken. Okay? But in other words, from a list of names, we cannot surely reconstruct the wrong that the law would forbid. So let me provisionally sum up what I've been building here so far. Law as we know it, the only thing that claims the proper standing of law, is an understanding that's pervaded as every point by the logic of morals. That explains why the law must be impersonal if it would apply to anyone who commits the wrong. And we say that the law needs to be justified. That's a distinctly moral understanding. It demands that when we impose laws, when we restrict the freedom of people, we remove their freedom of choice, we need to explain what makes that law valid and rightful, even for people who may disagree with it. The law bars racial discrimination in private businesses open to the public. Do we assume we apply that law to anyone who comes within the terms of the statute? That's a distinctly moral logic. Why do we do it that way? Nothing in the Constitution tells us to do this way, but it's a logic of morals that is embedded in law as we've come to understand it. And so if this is what we understand by law, my point is that this reflects a moral logic up and down, through and through, in which case the question we must ask is, why is it that virtually any lawyer or judge I talk to in the United States considers morality or moral concerns as something extrinsic to the law, something tangential, and rarely to be addressed, and not something that stands at the very core of the law? The readiest answer, I suppose, that Justice Holmes is one. Holmes famously said that he hoped that every word of moral significance could be banished from the law altogether. As he condensed the matter, moral rights, if there are any, these are for the philosopher, not for the lawyer. That this understanding came to be deeply absorbed by lawyers trained in the best schools was reflected amply enough in a line of Justice Brennan's from the case called Marr versus Doe in the 1970s, citing those words of Judge John Newman in Connecticut, that abortion and childbirth, when stripped of the sensitive moral arguments surrounding the abortion controversy, are simply two alternative methods of dealing with pregnancy. One might as aptly say that, stripped of its moral differences, a fireplace and arson are simply two different ways of heating a house. To strip the matters of moral significance from two acts simply removes any ground for any judgment of the acts that may be justified or unjustified, rightful or wrongful. And we'd ask, why would anyone wish to do that in anything we call the administration of justice? And that brings us, ironically, my conclusion, to the sad story of what established itself as conservative jurisprudence in America over the last 40 to 50 years. 2 years ago, 6 conservative justices took the critical step to slay the great white whale and overturn Roe versus Wade, the case that established a constitutional right to abortion. And true to the doctrines cultivated in conservative jurisprudence, they carefully steered around all the questions of moral substance that mark the center and real character of the case. For 50 years, the court, the Supreme Court, was teaching the overwhelming rightness and even the moral necessity of abortion. And now the conservative justices thought their work was done when they simply returned the matter to the political arena, while not even beginning to offer a corrective or countering moral teaching. They carefully avoid saying anything about the rightness or wrongness of abortion, and they would not even recognize the human standing of the child in the womb. 50 years earlier, in a case called Roe versus Wade, the lawyers from Texas drew on the most updated findings of embryology to show that that nascent being in the womb had been nothing other than human from its very first moments. The conservative dissenters in Roe versus Wade, Byron White and William Rehnquist, drew on nothing of that evidence and substantive argument, as they could have to draw an argument at once momentous and unstartling, namely, that the legislature of Texas has established compelling evidence for casting the protections of the law around that growing life in the womb. But instead of doing that, they retreated to a morally empty positivism, that the Constitution said nothing about abortion or right to abortion, and therefore federal judges were not in a position to proclaim any right to abortion emanating from the Constitution. But the right to marriage had never been mentioned in the Constitution. When the court proclaimed that right to marriage and struck down the laws that barred marriage across racial lines, and no conservative justice has called that judgment into question. As Gerald Bradley at the Notre Dame has pointed out, the federal government had long had reason to deal with the matter of abortion in military hospitals, diplomatic military outposts abroad, in the territories, the District of Columbia. The human standing of the child in the womb had not been a serious puzzlement till the Supreme Court officially made it in 1973. But James Wilson, at the time of the American founding, took up the matter of natural rights. The question, if we have natural rights, when do they begin? And his answer was, they begin as soon as we begin to be, which is why, as he said, the law casts its protection on the child in the womb as soon as we know it's there. But now we found Justice Brett Kavanaugh in the Dobbs case, putting his accent on the fact that the country was highly divided on questions of abortion, and that many pro-life advocates forcefully argue that the fetus is a human life, forcefully argue as though there were no objective truths firmed up over 100 years now in embryology, that the unborn child could never have been anything other than human from its first moments. In other words, in this mode of conservative jurisprudence now, the judges must affect not to know the plainest objective truth that bears on the practical judgment here. It will be a judgment left to the political branches. And worse than that, it was, as the minister said, a value judgment. Justice Scalia famously declared that there's no legal answer to the question of the human standing of the child in the womb, as though objective truths had no bearing on judgments in the law, that it was merely a value judgment. The term value judgment came into play with Nietzsche and Max Weber, when people lost their confidence in speaking about moral truth. So we would impart moral value to things as we happen to value them. Lincoln had famously said that the question of the time was whether the black man was or was not a man. If he was not a man, anyone who is a man could do with him what he wished. But if he was a man, he too had a right to govern himself. And Professor Harry Java said, that question of whether the black man is not a man, is a man, that cannot be a value judgment, depending on how many of us value treating the black man as a human being. And if that would make little sense, then it would make little sense today to say that the human standing of the child in the womb was merely a value judgment, resting on how much any one of us valued the life of that child in the womb. The Supreme Court, true to conservative jurisprudence, came to a momentous judgment while steering around the moral core of the matter. The justices returned the issue to the political arena, where we found the Republican political class always skittish about talking about a subject that leaves so many of their constituents uncomfortable. When the court passed the Civil Rights Act of 1964, it followed 10 years in which the Supreme Court acted as the Republican schoolmaster, teaching the moral wrongness of racial segregation. But the conservative justices returned the matter to the political arena, while offering no train of moral teaching to affect the understanding of the public and prepare the moral ground on which political men and women would have a firmer confidence in acting. The result has been a pro-life movement suffering a string of demoralizing defeats, with the public not fully understanding that women will not be denied abortions if they were faced with the risk of their lives or serious bodily injury, even though the pro-life movement has always given assurance that no abortion would be denied in those grave circumstances. And that brings me finally back to that great poem of Robert Southey's, On the Battle of Blenheim. 'Twas a famous victory. 'Twas a famous victory, the old man said, but what it was all about, we no longer exactly remember. Striking down Roe versus Wade, 'twas a famous victory. For conservative jurisprudence and for my friends at the Wall Street Journal, the real vice of Roe versus Wade was not that it licensed the killing of over 50 million unborn human beings, but that the court had overstepped its bounds. It's a fair bet to say that 25 years from now, abortions will still be performed in massive numbers in the blue or liberal states. And the spokesman for conservative jurisprudence will tell us, well, all they have the authority to establish is that there is no right to abortion bound up with the Constitution and detached from any anchoring moral ground. That was all that a conservative jurisprudence ever promised to do. Thank you.
Well, thank you, Professor Arquez, and thank you, Minister, for those two speeches, which I think you'll all agree have set an incredibly high intellectual and insightful tone for this event, as well as an also very high moral tone. So I'd like to ask now for our first panel to come to the stage. We have Professor Eugene Kontorovich of George Mason University, Richard Legutko, MEP, the co-chairman of the Conservatives and Reformists, Steve Hayward, senior fellow at UC Berkeley Law School, and to moderate, Attila Kovács, the director of the EU Research Centre at the Centre for Fundamental Rights.
Thank you. I would like to welcome you all, and I would like to welcome you here in the panel. At the beginning of our event, there have been many thanks to many of the colleagues. Let me start with this. Let me thank my team, and especially my colleagues here, Zsuzsanna and Fanny, for the excellent organization and taking the burden while I was out of office. Gentlemen, as we agreed the preliminary, there will be two sections of the panel. In the first section, I would like to give you the floor for like 5-7 minutes to make your kickoff speeches. And then, given the time constraint, we will have like a good 30-40 minutes for the discussion. We can go in alphabetical order, or we can go as you... By beauty, then I should start. Stephen, would you be so kind to start?
Well, all right, if you want. Yes.
I mean, here or in the...
No, I can.
As you wish. Yeah,
I
go
can
ahead.
go from here since we're going to try and keep short.
Perfect.
I thought the angle I would take on lawfare this morning is to narrow the scope in a slightly different domain, and that's to talk about the promiscuous overuse or corruption of the idea of human rights as it's affecting the rule of law, and where we really see politics overtaking the idea of the rule of law rightly understood. And I want to draw your attention to two recent pieces of litigation, one here in Europe and one in the United States. And I'll start here in Europe. About 4 weeks ago, the European Court of Human Rights, let me see if I get this right. Yeah, there it is. The European Court of Human Rights made what is being called, of course, a landmark ruling that held that Switzerland had failed in its duty to provide effective action against climate change under the Paris Accord. It is a case that's been going on for about 8 years. And of course, the sleight of hand, if you know anything about the Paris Accord, is immediately obvious. The Paris Accord has no binding treaty at all. It's 30 pages long. Whereas, if you know the history of this, the Kyoto Protocol 26 years ago was 1,000 pages long. That was an attempt at a real treaty that, of course, failed. And so the Paris Accord is really just a mission statement, and has it attempts to get countries to be like a potluck dinner where they'll say, well, we'll do this. And so they're picking on Switzerland because Switzerland supposedly isn't living up to its commitments. Lots of fanfare about this. Here's one quote from a press release. Today's ruling is unprecedented. This is the first time that the European Court of Human Rights has condemned a state for failing to take action against climate change, linking the protection of human rights to compliance with environmental obligations. And they talked about the requirements of the Paris Climate Accord. So right away you see a sleight of hand going on. Meanwhile, at about the same time over the United States, a pair of very similar lawsuits against the federal government in two different states. Both brought by an organization called Our Children's Trust, which apparently is trying to breed a new generation of Greta Thunbergs. And the suit claimed that young people have a constitutional right to a stable climate. There are other lawsuits like this pending in Canada, Australia, India, and Brazil at least. The American lawsuit actually claimed, this is from the language of the pleading, declaring the United States national energy system to be unconstitutional would resolve the controversy between the parties, thereby redressing a substantial cause of youth plaintiffs' constitutional injuries. And so the requested remedy here is that the American judiciary take control, executive and legislative, of America's energy system, just like that. 200 environmental organizations endorsed this suit. Significantly, since this went on for 9 years, both the Obama administration and the Biden administration opposed these suits, filed motions for their dismissal, and the Ninth Circuit Court of Appeals directed the district trial court to dismiss the suit more than once. By the way, if you're not familiar with American judicial politics, our Ninth Circuit Court of Appeals is the most notoriously progressive circuit, very friendly to novel legal theories, and also the most frequently overruled circuit by the US Supreme Court. So when the Ninth Circuit is telling a trial court a suit should be dismissed, but the trial judge kept allowing the plaintiffs to refile an amended complaint to keep the suit alive, and finally the Ninth Circuit lost its patience and said enough of this. They finally pulled the plug on the suit here just a few weeks ago. And so one important difference between American and European law is, what will be the enforcement of this suit against Switzerland? Are there going to be an injunction? Are they going to arrest the Swiss government? I'll come to what's really up to in a minute. but you should know that in some instances in America, our federal courts have usurped executive and legislative powers on rare occasions, once running a school district for many years, once taking control of a major highway project. Generally, this was viewed as I say, a usurpation of the other branch's power, and so it's not been widely repeated, and those instances have always been frowned upon. But what's really going on here is, I wasn't very familiar with the European Court of Human Rights, so I'm scratching my head and trying to make sense of how it all works, all these different conventions and treaties. So I pulled off my shelf the Oxford Handbook of Comparative Constitutional Law. Handbook's a misnomer. It's about 1,400 pages long. And you can't make heads or tails of all this because it's very vague. And that's on purpose. Because I think what's really going on in this particular case, but I think there are others like it, is the hope is, and every once in a while this is betrayed by the language that's used to describe these murky relations of the conventions on human rights in the court, is they're hoping that individual nations, the judiciaries of the individual nations will see, say, the Swiss case as a precedent and then apply it based on their own law in their own nation. So it's an indirect way of trying to ratchet up climate policy. And I don't think it's necessary to contest either climate science or climate policy and energy policy to see how insidious such lawsuits are. And the remedies for this, and I'll come to a conclusion, are difficult and complex, a lot more moving parts to all this. But I think fundamentally what needs to happen is we really need to get back to a more rigorous discussion of what we mean by human rights. And I have a lot of thoughts about that, but who can be against human rights? It's about humans and it's about rights. And if some rights are good, more rights are better. Well, we need to get back to, and I'm delighted to, fundamental rights. And what is the basis of all that? And so I will stop there and we'll carry on from there.
Thank you very much. Eugene, would you be so kind to continue?
Thank you. Thank you all for being here. It's a great pleasure to be in Budapest. I believe Hungary, for reasons maybe we'll discuss in questions, is currently one of the leaders of advancing the genuine rule of law in Europe, and I think actually events of recent weeks gave some examples of that, so ask about that in questions. But I want to talk about the EU's rule of law mechanism as a way of measuring countries' adherence to the rule of law. When I heard that the EU had come up with such a mechanism, I was fascinated as a social scientist, because measuring compliance with the rule of law is a genuine and interesting question for positive political theory. And I was also very surprised that the EU was doing it when I saw how it was doing it, because measuring the rule of law is not, you don't have to reinvent the wheel. There are, of course, several existing indices of rule of law. So if I was a political scientist trying to do a cross-country study, I would most probably be using the World Bank measure. There's a couple other measures. Freedom House has one, and there's a couple others, and these are indexes of the rule of law. So I assumed Europe would be using one of these well-worn indexes. But it turns out that they came up with their own. So I wanted to see what's in this index that's different from the other indices. I don't have a complete answer for you, because I can tell you that despite transparency being one of the elements of the rule of law, my legal education at the University of Chicago and 20 years teaching public law has not allowed me to thoroughly understand European legal materials, which they are, I think, to law what Judith Butler is to philosophy. They're not like they're not necessarily meant to be understood, but several interesting things emerge. First of all, there's a big question: what is the definition? How do you define the rule of law? And before we get into specifics, I would point out the EU definition of rule of law. It's one sentence. It's a Judith Butler type sentence. It's 3 times longer than the World Bank definition. So it is a 153-word sentence, which includes things like democratic, that's nice, pluralistic, I don't know what that means as a decision-making mechanism. It is heavily court-focused and actually mentions the power of the courts twice in a sentence, and involves also things like media freedom, migrant rights, and so forth. So I've created a table where I kind of chart the different elements of each definition. And the World Bank, Freedom House, other definitions have a lot in common. The EU definition has many elements, about 4 or 5 definitional elements, that are not found in any other definition, such as some kind of concern about executive power, which is separate from separation of powers, which is a separate criteria. Again, as I said, pluralistic, commitment to democratic values, and some kind of thing about minority rights. Contrast that with the World Bank definition, which defines contracts, which defines the rule of law as being the predictability of the legal system to function on pre-announced rules. The enforceability of contracts, it includes things not included in the European definition, such as strong expectations against expropriation. So if you're a farmer or industrialist who is going to be harmed by environmental measures, you'd like the World Bank definition better than it would accord with your expectations better. And mostly it focuses on what I would call procedural rule of law. Right? Is what you get what you would think by looking at the rules in advance? And does the system protect you from both expropriation from the government and also violence in the streets? As a result, because one of the things some of the other definitions mention is safety of property, we will see that actually on some of these metrics, Northern European countries do quite poorly because of their population choices. So there's some big differences in measures, in definitions. Then how do you measure those things? So the World Bank assigns numbers for everything, so it's transparent, adds them up, and comes up with an index. My initial goal in this project, by the way, this was supposed to be a research project that was interrupted by the war that started on October 7th, so I don't have conclusions. It's a big project. My goal was to compare how countries rank in the World Bank and other metrics with the EU metric. The problem is the EU metric is entirely qualitative and does not present a ranking. But I can tell you as a social scientist, when you look at the inputs into their mechanism, they're not serious. They're all soft inputs. So for example, they will send out a survey to some NGOs, but not all NGOs. Hey, could you please rank these countries for rule of law? That's a pretty amazing thing. And many of them also are what I would call duplicative and self-referential. They'll send it out to academics, to members of the EU officials, and those are going to be highly correlated groups. More fundamentally, when you look under the hood for what they're really asking, you will see it is actually what I would describe as undemocratic. Because how do they define some of these particular sub-definitions of rule of law? Asylum, migrants, media pluralism. By using specific rules from the Council of Europe, Venice Commission, and other bodies. Now, the EU is not particularly democratic. That is to say, it's insulated by many levels of ambiguity from actual Europeans who it governs. But the Council of Europe is simply not a body that anyone in the European Union has democratically elected. It has a different membership, different composition, is broader. Venice Commission, nobody in Europe even knows what the Venice Commission is. So they have created the terms which are then imported through like 3 levels of transitivity to be rules that are 4 degrees removed from anything anyone in Europe has ever voted for. So let's get to the assessment. It turns out there's a significant variance. So I can't actually quantitatively compare them because, again, the EU doesn't give you a score. They just tell you, are you in trouble or not, whereas everyone else produces rankings. So in the end, we know who has gotten in trouble with the EU, Hungary and Poland. So we assume they got the bottom ranking. Again, it's not a ranking. You can't peer under the hood and say, well, maybe, Italy, which has a lot of political violence, corruption, maybe it does poorly. You can't look at the score. But let's assume that for the EU ranking, Hungary and Poland have done worse. How does that compare to other scores? So in the World Bank and Freedom House scores, Hungary and Poland roughly rank around 18 and 19 and 20 out of European countries. In other words, better than countries against which no enforcement mechanisms have been taken, like Bulgaria, Croatia, Greece, Romania. They rank roughly around Cyprus. Most importantly, the EU rule of law mechanism has talked about crises in democracies. Whereas by these indices that we've studied, where Hungary does not rank at the top by any means, but certainly does not rank at the bottom either, the score has been amazingly stable. In other words, any of these political events that are being discussed don't even register as a blip on these. Hungary was 19 in 2020, it was 19 in 2021, 2020. These things are not picked up by the actual numerical indices. So what we see is the rule of law is being used, as a term to import ideas that are, let's say, so undemocratic that they were not even picked by the undemocratic representatives of the European Parliament, but of another, several other degrees. Non-transparent, non-quantitative. If it's not quantitative, you can't compare it across countries. And in other words, the rule of law mechanism of the EU, and I'm all for measuring rule of law. I study positive political theory, comparing courts. It's an interesting project. It lacks all aspects of what you would call the rule of law.
Thank you very much. Very good summary of the state of play. State of play, what the European Commission is doing. You already mentioned Poland, so I would like to give the floor to you, Richard. Your preliminary words.
Thank you. Good morning. I would like to make one general point and then put forward two more concrete theses. Well, general point is the following. One of the most ominous symptoms of the decay of Europe, possibly of the entire Western civilization, is the corruption of language. That is, the basic concepts we use have acquired exactly the opposite meaning. Now, rule of law is an example of the corruption of language. In its current use, it's the opposite of what it's supposed to mean, right? Rule of law is contrasted with the rule of man. The same goes for democracy, which now usually means the rule of the self-proclaimed elites and supporters, and the surrounding of the opposition by a cordon sanitaire. Pluralism, which means the acceptance of one political orthodoxy, diversity, which means homogeneity, and so on and so on. So this is just a point, a part of a larger process that has been going on, and the European Union has done a lot to make this process going faster and with more deplorable results. Now, the two points I want to make is, the first one is that the rule of law loses its role in a situation of political disequilibrium. I mean, for the rule of law to function properly, there has to be some kind of stability and some kind of political balance. Otherwise, the law will become an instrument to enhance the power of the main player. Now, the problem with the European Union is that it has been, from the very beginning, I believe so, it has been in the hands of the political left. It's a left-wing agenda which has been accepted and adopted even by the supposedly conservative European political parties, such as European People's Party. The European People's Party, the largest political party in the EU, does not have its own agenda, or very little of it. I mean, the entire agenda comes from the left. Now, no wonder when they resuscitated the concept of the rule of law and they have given it a partisan twist, it served to enhance their power. And it was quite successful in doing that. I mean, as a result of it, you have the European Commission. It was the European Commission that came up with the rule of law document first. Commissioner Reding from Luxembourg was the person who wrote this document. At the beginning, it was internal document of the Commission, and then became a sort of official program for the entire European Union. And as a result of it, the European Commission became a sort of super government, having new competency and become a supervisor of national governments. Now it can assess, evaluate it. You are doing fine, you are doing not so good, so you have to improve. If not, you will be punished. The European Parliament has acquired a new instrument, introduced a new instrument, a conditionality mechanism. Again, the institution that at the beginning was laughed at, Margaret Thatcher called it a Mickey Mouse Parliament. Well, it's not a Mickey Mouse Parliament any longer. It's quite a sinister institution. And the European Court of Justice granted these privileges to the Parliament, the Commission, and acquired a new leverage against the governments that reject primacy of the EU law. And then the mainstream, right? The mainstream, that is the combination of all these parties, they have acquired a new instrument against the bad guys, the conservative governments. So the rule of law has served the purpose was opposite of what it was initially meant to serve. And the second point I want to make is that the rule of law functions properly in a situation that is not revolutionary. And we live at the time of the revolution. We often forget about it. But this is the time of the revolution. And the next chapter of the revolution that started in 1960, the sexual revolution, nowadays it's called gender ideology. Now, if you think of it, that mankind does not consist of men and women, but of 50 genders. If it isn't a revolution, I wonder what it is. I mean, it transforms entire perception, not of the world as it is today, but the entire human history. You have to look at it differently. So this is a revolution. You have to change law and everything. So, and the European Union, of course, adopted wholeheartedly gender ideology, lock, stock, and barrel, everything, and they trying to enforce it on the member states, even though they shouldn't do it. Actually, they are not allowed to do it. But so what? You can read Article 9 of the Charter of the Fundamental Rights. The right to marry and the right to found a family shall be guaranteed in accordance with the national laws governing the exercise of these rights, unquote. Now, this article is dead. It is as dead as Article 5 of the Treaty of the European Union, which stipulates that the Commission and European institutions should follow the three principles of subsidiarity, proportionality, and conferral. This article is even more dead now after the rule of law offensive than it was before. Never was very much alive, but now it's as dead as one can imagine. Why did they kill the Article 9? Well, because it's revolution, and revolution is merciless in advancing its cause. And I would say the human rights doctrine was the vehicle used to kill Article 9. Why human rights? Well, first, because human rights have become a sort of secular religion and has at its disposal powerful national, international institutions. Second, because most of us have come to accept the assumption that rights have the absolute priority and can trump everything. And third, because the concept of rights is particularly susceptible to the might is right principle. That is, rights, those rights are stronger which have a stronger political backup, right? Rights killing rights is a well-known phenomenon. Rights to abortion kill the right to life. Over the last decades, we have been experiencing an unprecedented attack on freedom of speech and appalling growth of censorship, and mostly in the name of rights. So, well, okay, these are my 3 points.
Yes, thank you very much. I think in order to understand the current situation, sorry, close is the most important one. In order to understand the current situation, we need to step back a little bit. What went wrong with rule of law? Because in general, we might agree that rule of law is needed, rule of law was there, we need to have checks and balances in the society. But when it became a political tool, and the title of this panel is At the Intersection of Law and Politics, until which point is it a legal question, and from where it started to be like a political weapon? And of course, we have a wonderful geographical balance here, in coverage here, US, Israel, Poland. How do you see this? Why this topic emerged as a topic that we need to dedicate a 2-year conference to this issue?
Well, I can try first. Actually, I think Hadley Arkus in his opening talk gave us one large reason. You did say step back a bit, and that is we've stopped grounding our law in morals in the ways he laid out. And one part of that is, it's part of the progressive revolution in America and everywhere, was that we try to reduce not just moral but political questions to technical questions. And so that's what gives rise to the technocrats. And we're just going to apply scientific reasoning to problems and come up with, how could you object to what the scientists say? I think we've been disabused of that by COVID, but okay. There's one other aspect, though, that none of us brought up, but it's lurking in the background even more, is that part of the... Well, there are people out there a few of them will openly admit that sovereignty is an obsolete idea. The nation state is obsolete. Borders should somehow disappear. Often this is concealed. But it really comes up in the ambiguity of these rule of law questions, and it was sort of part of what implied in my talk is nations say they retain their sovereignty, but they want to accord some respect to what these international courts rule, whether it's the criminal court, the human rights court, and so forth. And they leave that in ambiguity, and I think that becomes now a new pressure point. So, look, the European Commission will put out rules that all the countries are supposed to consent to, but we've seen that's been unpopular. It was, the European Union fishing rules was one of the reasons that public opinion in Britain was so upset and led to the Brexit vote. So you want to conceal that that's what's going on, and that's why all the ambiguity of the laws and the status of these rulings. But to the extent that there's political opposition, popular political opposition to European Union overregulation, if you have the courts start to get in on that and bring some pressure in and try and then insinuate into the judicial systems as well as the legislatures and executive branches of the European Union members, that's another way of getting at it. And to not just fuzzing over sovereignty, but then fuzzing over the rule of law rightly understood is essential to that project, which is a political project.
Thank you, Eugene. What do you think? What is at the intersection of law and politics regarding rule of law? And before the brutal attack of Hamas on Israel, in Israeli domestic politics, this institution, rule of law, the power of courts, and the court reform was very high on the political agenda. What could have happened with that political agenda if that brutal attack wouldn't have happened since then?
So I think rule of law has come to be used in a certain sense in Israeli political discourse in a way similar to European discourse, meaning a set of policy outcomes rather than, or as my father likes to say, the particular set of public policies arrived at in Western Europe in the early 21st century is the definition of the rule of law rather than any particular kind of process. And it's designed to disguise that. Part of the mechanism, and I see this when I read through the EU rule of law assessment system, part of what's happened is it's an assertion of power by elites and bureaucratic elites. So the EU mechanism works by sending a survey to a certain kind of members of a certain cosmopolitan class, that is to say, legal academics, people at think tanks, and EU officials who are themselves part of this class. Their views are going to be very highly correlated. Similarly, in Israel, the way judges are picked for the Supreme Court is the judges have a vote and the lawyers have a vote. The vote of the lawyers and judges is very highly correlated. But you mentioned the October 7th attacks. I want to say something in connection to this, which I think has been a real victory for the rule of law in Europe for the first time, and it happened this week. Because there's a thing that has happened that has long stained the rule of law in Europe. There have been historically accusations that Jews are killing Gentile babies, and Jews who would often not be enfranchised in these political systems, and they would be investigated, and a show trial would be put on. That story is repeating itself before our eyes with the International Criminal Court, which is a court in which Israel is not represented. That is to say, it has no legitimacy. Israel is not a member. Israel didn't choose. Israel has no choice over the judges. The professional staff, I'm writing an article about this, employed by the prosecutor are people who have long called for boycotts of Israel and declared Israel an apartheid state already 10 years ago. In other words, people without any impartiality. The treaty of the ICC itself was actually tweaked by Algeria, which did not join in the end, but in negotiations tweaked by Algeria specifically to criminalize the existence of Israel. One of the reasons Israel didn't sign. And the crimes that Israel is accused of, for example, starving the Palestinians, may not even have happened in the sense of it's not clear that anyone has actually died of hunger. And if they did, it is likely caused by Hamas stealing their food. So at the end of this completely illegitimate system, the democratically elected leaders of Israel have been indicted. And we can now measure what rule of law means in different European political situations. So most European countries kind of said, yeah, it's not great, but didn't want to take it. We don't like it. We're not happy about it, but they grumbled. The German government said, if they issue a warrant to arrest the Prime Minister of Israel for defending Israel, we don't like it, but how can you not follow the law? And yes. And then comes Mr. Orban, who said, this has no connection to justice or legality. Hungary will not enforce such warrants because they have no basis in legality. And as a member of the ICC, I thought that was an extraordinarily important statement, unfortunately rare among the countries of the world, but a real victory for the rule of law.
We will get back to the consequences of the Hamas attack, but let's get to the Polish situation. And what we have seen in the last couple of months is the restoration of rule of law in the name of Brussels and in the name of the Tusk government. It highlights the fact that rule of law is purely subjective, and it's a political weapon. Government change in Poland, and everything is right. What can we do? What can Polish opposition do to tackle this situation and to highlight the purely subjective approach of the European Commission?
I wish I could answer that question. I mean, we have to win. We have to win the elections, and then the European. There must be some political change within the EU. That is, I'm not optimistic, and I don't think that after the next European election there will be some substantial shift to the right and to the rule of law and common sense in the EU. It's a long process, but without the change within the European institution, without introducing some kind of political balance, we cannot hope for any improvement. I mean, the European institutions have been in the hands of the same political group for decades. They believe that they do whatever they wish because their power is God-given and it will last forever. So they need some kind of shock to rethink the position. But also I'm sorry to say, but a lot of Polish population still has some illusions about the EU. It's not easy to conduct a more sober policy vis-à-vis the European Union because you do not have the support you need. About 70%, I think the recent polls, 70% of the Polish population wants the country to be a part of the EU. And if you want to be in the EU, then all the consequences follow. Also, let me remind you, even if you are outside the EU, it does not have to be the best of all possible worlds. I mean, the Great Britain left the EU, but I'm not sure that the EU left Britain. And yes, but if you can, I go back to the question you asked, Steve. Yeah, I think first from the very beginning, the project was contaminated, so to speak, because from the very beginning it was conceived as a mission. So if it was a mission, then you have a division between two groups: those who are chosen, so to speak, and the sinners, who are against it. So from the very beginning, there were the good guys and the bad guys, and you deal with the bad guys. All means are accepted, right? And then there were some bad guys for quite some time. There were some bad guys. The bad guys were France under de Gaulle. There was Great Britain, and also the Netherlands. And a part of the blame is falls on France that changed course. The Great Britain came to accept the ruling of the European Court instead of sending the European Court packing. And once, the European judges had managed to get a grip on the European law, and the power increased. And now it's extremely difficult to do anything about it because immediately all the institutions and they work in solidarity. The European Court, the Parliament, the Commission, and some extra outside EU institutions like the Council of Europe, right? Yeah, and so it's very difficult, and the leaders of the governments, even those governments that are clearly dominated by the EU, for instance, from Central Europe and Eastern Europe, whenever they come to the European institution, whenever they come to the European Parliament, they start and they finish, and in the middle they put the praise of the European Union, how grateful they are to the European Union, how magnificent an institution it is. Now, if you continue to do it, you will have what you get now.
Thank you very much. Let me get back to the consequences of the Gaza situation. What we are seeing is in the U.S. universities, and you both work at U.S. universities, burning Israeli flags, attacks on Jewish students, etc., etc. How would you consider the situation in the light of rule of law?
In light of which?
Rule of law. I mean, in line of...
rule of law, sorry. Well, it would be nice if some of our university leadership, not to mention local law enforcement, would actually enforce the law. I mean, these are public spaces in many cases in violation of clear statutes, and it's just a lack of will. Eugene thinks I hesitate to call it a silver lining, but this has shocked a lot of people, including a lot of people who were not paying attention to what's happened to our universities. And people are waking up to realizing, oh, wait a minute, where did all this nonsense come from? Nonsense is too nice a word, really. It's really quite evil and pernicious. And slowly the scales are falling from the eyes. Oh, we've been teaching this. I don't know if you know this, Northwestern University had an encampment. Their capitulation was to give scholarships to Palestinian students from Gaza and to create new professorships for Palestinian faculty. Well, we know what the students and those faculty are going to be like. It's absolutely astounding. But that's the character of leaders we had. And the idea of enforcing the law, well, that's just the criminal laws, the basic ones, seems to be out of the question.
Thank you, Eugene.
I'm a big proponent of free speech, and I'm very grateful, as Stephen suggested, I'm actually very grateful that there's so much free speech on American campuses now, because we know what they're really thinking, and I think what the students are performing is what they were taught by their professors, and what is, let's say, unspoken and tacitly understood ideology in much of Brussels, and that's why European policy to Israel looks the way it does. But we see even, we mentioned in the rule of law categories, protection of minority rights. So American universities have gone very far in the protection of minority rights, absurdly far, with safe spaces and rules that anything that makes any student feel uncomfortable is grounds for immediate expulsion. Now, I was critical of those rules and remain critical, but one would have thought with such, what my father likes to call actual existing liberalism, a play on actual existing socialism, when you have under this actual existing liberalism such rules, and there are going to be protests against Jews are going to be barred physically from public buildings, the full force of the university will come down on them. But it turns out that's just not what minority rights, it's like, again, one of these esoteric terms that you need to be a member of a particular elite to understand what it means. Of course it doesn't mean this, it just means that.
Let's get back to more peaceful waters. Eugene, you mentioned how wrong and in many points the current framework of rule of law of the European Commission. But can an alternative framework be developed to challenge this in European context or global context? How would you see that?
Yeah, so
but it's also a question
I think countries that would be interested in pushing back on the European framework would be well advised, I think, to take existing frameworks and say, what's wrong with this? Well, indeed, if you value transparency, the biggest problem with the EU framework and the EU measure is it's non-reproducible. Right? That is to say, you can't look under the hood and see how they got there, because it's not quantitative. What weight you give to such values. Say, we want something that meets the EU debt values, transparency, etc. I think it would be a very fun project to rank the EU's own instruments along these values of democracy and transparency, but develop an alternate framework, and those frameworks already exist.
Richard, what do you think? Can we come up with an alternative framework? How can we challenge the current setup, the current annual rule of law reports of the European Commission?
Well, there has to be rebellion on the part of the member states, some of the member states. That would make a difference. I mean, mind you, most of these new competences of the Commission or the Parliament cannot be substantiated by the European treaties. I know that the European treaties are not perfect. In fact, they allow for diverse interpretations. They are not very precise, but there's nothing in the treaties that would allow the European Commission to be the judge of the state of rule of law in member states. When they first came up with this notion of rule of law, and Commissioner Reding wrote her document, and they sent it to the Council of the European Union, and the opinion of the legal services were devastating. I mean, it's a blatant violation of the treaty. So what? They put this opinion into the shredder, and they went along with the business, and they got what they wanted. So I think that there has to be some rebellion on the part of the member states. Hungary is not enough, with all due respect. There should be more Hungaries today in the EU.
Yeah, go ahead. So I just have to comment that I've long found, as an American, it somewhat peculiar or bemusing that the word competency and competence is used so much in official discourse in the European Union. We're a new competency of the European Union. The word competency is not used in American politics because one of the most evident things in America is the incompetence of our government at so many levels. If any national political leader came up one day and said, we're going to implement some new competencies in government, 75% of Americans would laugh out loud. So where do we get with all that? Picking up on the last point is there's this coordination problem. There's Hungary, very resolute, knows what it's doing. You have some other leaders who have some instincts and impulses against the centralization and abuse of the rule of law in the European Union. The Prime Minister of Italy, for just one example. But there's the coordination problem exists. And so that's when I start to think in more practical terms, because I'm kind of a schemer. I think if there's reports on the rule of law, there need to be counter reports on the rule of law. And if you can get several heads of state or jurists to sign on to it, then you start betting a contest of opinion. And this may sound grandiose, and maybe it's already in motion, but I think that in America what's been so important to our legal arguments was the 40-year effort of the Federal Society in our legal academies has borne fruit. And I think that ought to be replicated in some fashion in Europe. And I know the Federal Society is opening chapters over in Europe, but more, please. That's more and faster. Well, okay, that could work, right. But don't use the word competency.
2024 is the year of elections. You already mentioned that in like 2 weeks we will have the elections here in Europe and also in November in the US. Do you foresee any change, of course, depending on the outcome of the results of the elections, regarding rule of law approach, and also in the US campaign, and let me start with you, Steve, all the witch hunt against Trump and the institutions, etc., how do you see the future of this rule of law and politics, rule of law and institutions in the US?
So one prediction is if Trump wins the election, he will be indicted by the International Criminal Court, or at least someone will try. I'm not actually entirely joking about that. I'm sure there will be a motion made. I'm sure it will fail, but someone will think this is a good idea for some reason to indict him through the International Criminal Court, which is how deranged Trump makes people. I think you will see from the Trump administration some serious efforts to rein in what we call the administrative state, which is the self-perpetuating permanent bureaucracy. A lot of serious thought going into how to do that. And I'm optimistic about that. It's going to be a titanic struggle, lots of wins and losses, but you are going to see, I think, I'll put it this way. I mean, I'm familiar with the plans made when Ronald Reagan came into office in 1981, and there hasn't been a sustained effort since then at quite that level, but the kind of plans being made now for a Republican administration are much, 5 more levels of detail down than there were in the Reagan years. And so there's something to fight with.
Richard, how do you see the European situation? You didn't hear, or you didn't sound too much optimistic about the emergence of the right-wing conservative political parties. What do you expect after the EP elections, and also in light of the new commission in November?
Well, I'm not optimistic because I know these institutions, and I think that less than 51% majority would not really matter. I mean, you can have a bigger group with an cordon sanitaire, not enough votes, no matter how you count it, and also they are on the conservative side. There are political parties which do not see eye to eye. I will not give you an example, most of you know. So the politicians or the commentators who say there might be some big conservative group in the European Parliament that will affect the choice of the election of the Commission President and so on and so on. This is not likely. But yes, I think the conservative side will be stronger, which will be enough for the ruling majority in the European institutions to become even more, shall we say, dedicated to the destruction of the conservative movement in Europe. Yeah.
Very interesting prediction. Gentlemen, we have 3 minutes left, 1 minute each. If we talk about rule of law in 5 years, how do you see what will be the direction, what we will be talking about? Could it be in your respective countries, in the context of Israel, US, Poland, or in the European context?
All right, I'll try first. I have no idea. I've lately, in a pessimistic mood, been saying things are going to get worse before they get worse. I'll just limit myself to the United States and say that Trump appointed a lot of great judges, so did President George W. Bush. President Biden has been appointing very radical judges. So I think we're going to see some real conflicts in the American courts over the next several years, and that'll, district court, and it'll be appealed, and the Supreme Court's going to have to up its workload, and that's going to be a big battleground.
Well, the new government in Poland said that they would try to make the law and justice illegal. I don't know if they decide to do it. I mean, making it illegal or preventing it from being present in the public space is a radical movement, a radical move. But I think they are ready for more blood. It's true that the current Polish government consists of, as somebody said, thugs and morons, but that doesn't make them less ruthless in pursuing their goals.
Eugene, the final take is yours.
Also, I definitely think that the politicized prosecution of heads of state and party leaders, which, by the way, Israel is unfortunately a pioneer of and has been metastasized in the United States, is certainly going to be mainstreamed as it only gets easier the more you do it. The mainstreamed as a tool to defend from the barbarians at the gates. I think that's definitely going to happen. And I think to combat that, conservative forces need to do something which is very difficult for them, which is not merely conserve, but also rechange institutions, destroy institutions, create new institutions, rather than just trying to manage within existing dysfunctional institutions.
Gentlemen, thank you very much for your participation and your interest. So, ladies and gentlemen, thank you very much for your attention. We can continue the discussion during the coffee break. Thank you very much.
So for our next session on Hungary, Poland, Spain, case studies and triple standards, it's my great pleasure to announce to you our speakers. Jerzy Kwasniewski, the president of the board and co-founder of Ordo Juris Institute in Poland. Ricardo Ruiz de la Serna, associate lecturer of San Pablo CEU University in Spain. Miklos Santo, the Director General of the Centre for Fundamental Rights, our partner organisation. And to moderate this panel, my colleague and friend, Gege Dobozi, the Senior Research Fellow of the Danube Institute. Thank you.
So, dear guests, esteemed professors, current and former politicians, think tank colleagues, and distinguished commentators from all around the world. During this conference, this should not come as a surprise, but speakers will discuss various national interpretations of the rule of law, whether it be the English concept, the Rechtsstaat, or the État de droit. In this speech, however, I will focus on the Hungarian perspective. In Hungarian, jogállamiság is the word that covers the concept of the rule of law and what should it mean. This word signifies the ideal functioning of the state, where the branches of power operate by, for, and of the people. This concept refers neither to a fixed set of conditions nor a quality, but an ongoing objective, a beacon for every civilized nation to strive forwards. However, only a state with full external and internal sovereignty has the right to duty to pursue this noble goal, and only in accordance with valid and effective law. Let me highlight two key terms of the Hungarian term jogállamiság: law and statehood. In Hungary, these concepts are enshrined in the Basic Law, which ties our constitutional framework to our rich historical constitution. This framework is the bedrock upon which constitutional bodies must relentlessly pursue the proper operation of the rule of law. It is this very foundation that also empowers Hungarian authorities to cooperate with their counterparts in other member states and the bureaucrats in Brussels, jointly fostering stability, peace, and prosperity throughout the European Union. And this is why conservative Hungarian constitutionalists raise their eyebrows when confronted with the EU's current interpretation of the rule of law. We see their so-called legal concerns as thinly veiled political arguments. This is only because the rule of law's interpretation makes it a perfect weapon, horrible addictive, a basis for a substantive lawfare. Time constraints prevent me from fully tracing how the abstract concept of the rule of law became entrenched in the mainstream EU politics. However, December of 2020 surely stands out. During the European Council meeting on the 10th and 11th of December, an agreement was reached on the multi-year budget, the post-COVID recovery fund, and the rule of law conditionality rules. Initially, the legislative package contained vague rules allowing the European Commission to interpret the rule of law broadly, leading to unpredictability. This was further complicated by the Commission's reliance on unclarified soft legal documents from various EU organizations. Thanks to Hungary and Poland's concerted efforts, the agreement of December 2020 imposed a crucial requirement. The Commission must evaluate information solely based on its goal of protecting the EU's financial interest. Initially, I was optimistic about this agreement. In fact, I can recall the optimism with which I wrote the article about it at that time. However, it soon became clear that the Brussels elite saw it as a stepping stone to their federalist utopia, the United States of Europe, undermining member state sovereignty. In April 2022, following a decisive Hungarian election victory, which obviously infuriated Brussels, the European Commission invoked the rule of law conditionality mechanism against Hungary, blocking billions of euros due to vague legal concerns. Poland's then conservative government faced even harsher financial blocks despite even murkier legal grounds. Meanwhile, member states supportive of Euro federalism, like socialist Spain, accessed resources without any barriers. Notably, the EU overlooked Spain's enormous constitutional crisis and clear violations of the rule of law. Similarly, significant corruption scandals in Germany and other parts of Western Europe, such as Wirecard and Airbus, were ignored. And now, since Poland's political landscape has shifted towards federalist support under a pro-Brussels Donald Tusk, their financial bloc issues seem to be resolving, even as he has committed the kinds of rule of law violations that should be of grave concern. This shift suggests a troubling triple standard. Sovereignist Hungary remains punished, federalist supporters remain unaffected, and Poland is granted clemency while highly likely reducing its state sovereignty. Now, if double standards weren't tough enough, this scenario definitely stretches the framework of the EU treaties. Let me clarify one last thing. Article 2 of the Treaty on European Union prescribes the rule of law as a common standard, emphasizing human dignity, freedom, democracy, equality, and human rights. I am definitely in favor of that. Article 4 respects member states' sovereignty and their national identities. More than welcome. Article 120 of the Treaty on the Functioning of the European Union mandates an open market economy with free competition, favoring efficient resource allocation, and this would be one of the main goals of the cooperation. But in reality, the Brussels-imposed rule of law framework curtails member state sovereignty, placing non-cooperative member states under political and financial quarantine. So, we now find ourselves in a strange Euro trilemma. At this point, the EU cannot simultaneously enforce standardized rule of law requirements, promote sovereign state interests, and economic prosperity at the same time. The clash between federalists insisting on a standardized approach to the rule of law and those valuing state sovereignty paralyzes the EU, hindering economic interests. Pursuing economic recovery through a standardized approach to the rule of law sacrifices state sovereignty, which is unacceptable and unconstitutional, for example, for us Hungarians. Therefore, we strive to discover a solution that drives economic growth within a community of sovereign states while upholding the integrity of the Copenhagen criteria. It is imperative, after all, that each member state respects the rule of law and champions this principle, but on a national level. So, thank you for your attention for this opening speech. And now I will give the floor to my panelists. Thank you very much. So, let me start with a very basic question. Where are we now within 2 weeks from the elections? Miklos, please start.
Thank you very much, and I'm quite happy that we together, the Danube Institute, the European Magazine, and the Center for Fundamental Rights, we together were able to organize and host this conference. I would like to greet you here in Budapest. And to answer to your question is that now we are here in Budapest, 2 weeks prior to the elections. Look, your question refers to where are we now prior to the EP elections if it comes to the rule of law. And my very first populist and propagandist answer is that it's... I know that this will be a little bit a strong statement, but it's really useless to speak about rule of law since the accession of Ukraine to the European Union is on the table. Because in the past few years, we Hungarians, but I'm sure that is true for our Polish friends, we learned that the rule of law is a very important category. That's the heart of the functioning of the European Union, and thus it should be taken very seriously. Now, as we do, and I'm not against our Ukrainian friends. Do not misunderstand or misinterpret my words. But to officially speaking about the accession of a state which is under Russian aggression. And as a result, its state functions cannot be executed at 100%. At least it's interesting how we define rule of law in the European Union. What's the problem nowadays? The biggest problem with the current concept of the rule of law is its application by Brussels, because as we see, or as I see it now, Brussels uses the term rule of law as a political weapon to enforce its ideas or its dictates on key issues like migration, for example, border protection, gender ideology, or the war itself. So we are witnessing a procedure in which, or according to which, originally the concept of rule of law was some kind of a, procedural or technical question, that certain procedures, certain institutions, and certain basic human rights should be guaranteed in every and each member state. But now we learned that the rule of law is a very substantial question. It's about an ideological content, because they define rule of law on democracy. But as it became very obvious for nowadays, there is only one democracy in the eyes of Brussels, and that is liberal democracy. There is no any other alternative version or versions for democracy. There is no social democracy, there is no Christian democracy, there is only one concept of democracy, that's liberal democracy, upon which a rule of law should be based. So that's what we do see now, 2 weeks before the EP elections, that there are, of course, various political weapons in the hands of the Eurocrats. One of those political weapons is rule of law, and they are trying to use this one for political and financial reasons as well. If there is a sovereignist government in Budapest, or in Warsaw, or in Pozsony, in Slovakia, then concerns about rule of law and democracy, or concerns about corruption related to the conditionality mechanism arises. If there is a leftist liberal government elected in Poland, then suddenly the procedure related to the rule of law against Poland is seized without any type of officially and legally implemented modification or amendments to the respective Polish pieces of law that raised concern in the eyes of the Brussels elites. If there is a freshly elected sovereignist government in Slovakia, then again, concerns about rule of law arise. This shows me that we do not have a legal debate here. We do not have a law-based pro and contra argumentation situation here. We do have here a political debate based on different approaches towards fundamental values. How do we approach to the Judeo-Christian heritage of Europe? How do we approach to national identity and state sovereignty? And how do we approach to the family? And of course, how do we approach to different geopolitical challenges? And this is also, do not forget this. This is also on the table for the upcoming election. That is for sure. That we We also decide about important geopolitical issues, but we also decide about what type of interpretation of rule of law should be followed in Brussels.
Thank you. Mr. Ruiz de la Serna, my next question is for you. Well, I said that the rule of law is a perfect weapon to set the stage for double standards. The past few years in the European Union and the European mainstream media was about bashing Hungary and Poland because of their so-called grave concerns related to the rule of law. There's even a brand for this in the German media, Polen und Ungarn bashing. So the imperfection of this concept makes it a perfect weapon to do that. But what about Spain, during which, during this period when the European public sphere was busy bashing Hungary and Poland, as far as I know, there has been some really concerning issues regarding the rule of law. The whole constitutional system was maybe turned upside down there, or we could read articles about that, of course.
Well, thank you very much for the organizers for having me here, the Center for Fundamental Rights and the Danube Institute and the European Conservative. Let me put it this way. We are dealing with two different kinds of injustice here. Hungary and Poland have been suffering an unjust actions from the European Union, and Spain is suffering unjust actions and decisions from its own government under the eyes of the European Union. Let me take a couple of minutes to tell you how the rule of law is being demolished in Spain step by step. We should start like in the Bible. Bereshit bara Elohim et hashamayim ve'et haaretz. Bereshit, in the beginning, or in principle. Well, in principle was the promise of the rule of law in the Constitution of 1978. That was the idea that rule of law was one of the new steps after Franco's regime. It was the promise of limited power of the government and fundamental rights and freedom and equality and justice. And it was a promise that for many years was honored by the Spanish law. But after probably 2004, perhaps we might go to the 80s, but definitely after 2004, that promise was betrayed by the socialist government and by other governments that tolerated and kept the socialist policies. And let me sum up in a couple of minutes how it was done. First, a legal war against equality was waged. Equality between men and women, equality between born and unborn children. Some of them were protected, some of them were not. Obviously, I'm talking about the abortion. Later, we had the legal war against freedom, with laws on memory, for instance, banishing or limiting freedom of speech and freedom of academic research. Later, we had a war against the control or the limit of power. And here we have the assaults and the attempts to control the judiciary, which is something that we are seeing these days in Spain as well. We have seen how the president of the Constitutional Court, for instance, has been appointed between political candidates. One of them, the one who was chosen, is the former Attorney General under a socialist government. He's now the president of the Constitutional Court. Finally, there came the legal war against justice, with the amnesty granted to the politicians who were convicted criminals, against the politicians who led the coup d'etat of 2017, the Catalan separatists. And all this led, these attacks against the rule of law, against freedom, against the control and limit of power against justice led to division, to violence, to the reward of Hamas that we have seen these days from the Spanish government. So this led to what ancient Greeks will call a tyranny, which is a power without any limit, power without any control. This is leading to double standards among citizens. You have groups of privileged citizens who are entitled special rights because they belong, for instance, to the so-called vulnerable minorities. You have a problem with human rights, which are used as a political tool to harm liberty. I was very interested in this notion of bringing the notion of fundamental rights back into the picture. So this is my personal description. I'm not representing any institution. I'm talking just in a personal capacity. But you were asking, what are we? Well, this is what we are in Spain. The rule of law is under attack. And I would like to finish by remembering the words of my favorite Hungarian poet, Petőfi Sándor. He wrote a beautiful poem whose first verse is Szabadság, szerelem, freedom and love. And now we're seeing the attack against freedom, and we're seeing also an attack against love for family, love for your country, love for any natural community, which is probably the real problem. The rule of law has been the alibi to attack nature. So we don't have any more a nature. We have only people making decisions. Thank you very much.
What you just said about this, well, that's concerning. And as a huge Star Wars fan, I also love parodies, and well, Spaceballs is one of my favorites. And there's an episode in which they say that, "Sir, there's a problem with the radar." And we talked about double standards, and we were talking about that radar. But Mr. Kwasniewski, as a Polish think tank president, how do you assess these triple standards? The title of this panel is, well, not double standards, but triple standards. How does it feel like being in the purgatory?
Of course, I'm a witness of this phoenix of rule of law rising from the ashes in Poland now. And with the European Union cheering our government as the one that brings back Poland to the force. And yes, I'm well aware, and we all should be well aware, that the rule of law has been weaponized in the previous years, and it was not done yesterday. We observe gradual weaponization of rule of law, at least since year 2000, an Austria case. And this weapon has been perfected, mastered, and developed to its fullness with Hungary and Poland in the previous decade. And with time, it was this substantive rule of law approach that you mentioned before, Miklos, that dominated formal rule of law approach. That was initially the proper approach to a rule of law problem. So with the substantive rule of law approach, values easily redefined, as Richard Legutko said in the previous panel, according to the political will of politics, of policymakers, become the content of the principle of rule of law. And just to show what really happened in Poland, in the previous 6 months, in February, our Minister of Justice, Adam Bodnar, presented Polish action plan on rule of law for restoring the rule of law at the meeting of the General Affairs Council of the EU. And it took only 3 months since then, without any single action of the government fulfilling the action plan, to read the European Commission press release from the 6th of May. I quote, "The Commission considers that there is no longer a clear risk of serious breach of the rule of law in Poland, within the meaning of Article 7 of the Treaty of the European Union. Poland has launched a series of legislative and non-legislative measures to address the concerns on independence of the justice system. It has recognized the primacy of EU law and is committed to implementing all the judgments of the Court of Justice. Nothing has been done on the legislative level in Poland since December. However, what are those non-legislative measures that were quoted and named in this official press release? And the press release was seconded by Ursula von der Leyen saying, "Today marks a new chapter for Poland." So let's see what is the new chapter for Poland. And we have to say that Poland, in fact, experienced a coup powered by the weaponized rule of law. And it is what happened in the 6 months after the government was sworn in on 13th of December 2023. The unconstitutional implementation of so-called transitional justice that led to takeover of public media, courts, prosecutor office with the National Prosecutor Office. And we are on track to finalize taking over the Supreme Court, National Council for the Judiciary, and Constitutional Tribunal by liberals as well. And I'm very well aware, and already Richard Legutko mentioned that this coup will be crowned with a purge among the ranks of 2,500 judges nominated by Andrzej Duda during the last 6 years. Then imprisonment of the key leadership figures of law and justice, and dissolution of the party if it does not implode under the heavy burden of persecution, investigative committees, controlled leaks from the criminal prosecutors' offices, without any possibility for defense. And there are 5 principles, 5 priorities of the liberal takeover of the state. 5 priorities that led Ursula von der Leyen to say, today marks a new chapter for Poland. The first, to take over public media. An unlawful attack on the public media took place based on a resolution of the Polish parliament, not on the legal act. And on the same day, Minister of Culture and National Heritage, Colonel Bartłomiej Sienkiewicz, appointed a new supervisory board and appointed new management boards of all public media in Poland. And just imagine, it's a picture very important for Polish people that during this takeover, forced takeover of media, the media broadcast signal has been intentionally turned off for the first time since Marshall State was introduced in 1981. The broadcasting signal was out. The second priority, courts of law. Again, not a legal act, just a resolution, a declaration of the parliament, taken on 20th of December last year, stated that Sejm's, the parliament's own acts since March 2018 till May 2022 regarding selection of the members of the National Council for the Judiciary were adopted in flagrant violation of the Polish constitution. So it is the parliament who now judges the constitutionality of legal acts. In this context, the Minister of Justice proposes a procedural test of independence, which aims to verify impartiality and independence of more than 2,500 judges appointed to their position after the change in the rules of the National Council of the Judiciary. Test of the independence is, of course, framed by the executive and legislative branches that interferes with the core of judicial power, constitutionally guaranteed status of judges as irremovable and equal. On December 15th, Minister of Justice Adam Bodnar published a decree, not a legal act, not a declaration, a decree, giving a binding instructions to the judges of Poland concerning court verdicts and written grounds. According to the so-called Bodnar's decree, judges are to give priority to the European Union law against Polish constitution. In the meantime, Adam Bodnar exercised his ministerial powers to suspend presidents of the most important appellate courts in Poland, without regard to the formal requirement, legal requirement of involvement of the National Council of the Judiciary and against the interim orders of the Constitutional Tribunal. Third priority of the liberal takeover, all power of criminal justice has to be implemented against opposition. Under the Article 14 of the Polish law on public prosecutor's office, the most important national prosecutor and other deputies of the prosecutor general shall be appointed after having obtained the opinion of the President of the Republic and dismissed upon his written consent. Without any chance for support from Andrzej Duda in this liberal takeover of the National Prosecutor Office, Minister of Justice ruled that National Prosecutor Dariusz Barski never effectively took his place, took his office, as his appointment in 2022 was tainted with a formal defect. First ruling of the Ministry of Justice led to another. Donald Tusk appointed new National Prosecutor Dariusz Korneluk without obtaining an opinion of the President. Oh yes, according to Ursula von der Leyen, today marks a new chapter for Poland. As a result of the challenged status of judges, unlawful appointments of the prosecutors, hundreds of thousands of court rulings, hundreds of thousands of pending criminal pretrial proceedings and decisions come into question. At the same time, politically motivated investigations are made public by formation of free investigation committees in the parliament. Key witnesses of the prosecution present their testimonies publicly in the parliament without the presence of the defense and without any possibility to counterbalance or question their words. Homes and offices of 30 politicians, board members of conservative non-governmental organizations were searched, documents, computers, phones taken. Some of them, with Father Michał Olszewski, were arrested. Fourth priority of the new rule of law and liberal takeover, Constitutional Tribunal. On March 6th, Sejm accepted a resolution declaring 10 different acts of parliament concerning Constitutional Tribunal to violate Constitution. 3 of the nominations to the Constitutional Tribunal were declared to be invalid. 3 judges were declared to be non-judges by the parliament. Many decisions of the Constitutional Tribunal were declared null and void. Since then, Polish government, rule of law government, ignores all interim orders given by Constitutional Tribunal. The last, 5th priority, Supreme Court. And we are waiting for the final steps and the final takeover of the Supreme Court. According to the action plan presented by Adam Bodnar in Brussels, to strengthen, I quote, to strengthen the independence of the Supreme Court, Poland plans to introduce changes to the Supreme Court. These will mainly concern the Chamber of Extraordinary Control and Public Affairs, which, according to the case law, is not an independent court established by law. Details are yet to be published. And to give a face to a case, judge of this chamber, Professor Aleksander Stępkowski, one of the most prominent minds of the legal field in Poland, sits with us and is speaker at the conference. Those are the faces and victims of the rule of law. And yes, truly, today marks a new chapter for Poland. How to evaluate this situation is an obvious conclusion that since December, Polish liberal government implements radical revolutionary policies of hostile takeover of institutions and of the state itself. This is made possible because of long-term developed substantive rule of law approach that dominated in the jurisprudence of European Union over the formal rule of law approach. Supporters of the formal rule of law approach consider that it is sufficient for public authority to act on the basis of the law, regardless of its content. While apologists of the substantial rule of law approach present that the opinion that the rule of law must be subject to a law that not only was introduced in a proper way, but which itself is just. Polish-Hungarian case studies prove that the substantive rule of law became a tool of lawfare. It could easily be foreseen as the risk of political weaponization of the rule of law increases with the axiological diversity of a given community and reaches its highest level when attempting to apply rule of law in this substantive approach to the broad and diverse international community, what will happen next? In reply to that observed development of the rule of law doctrine, we should propose two-tier, two-level solution that will combine both objectivity of formal law approach and much-needed moral and cultural standards under substantive rule of law approach. While the first, formal approach, should be applied to ensure a minimum convergence with respect for diversity on international level of European Union, the second approach will be best implemented at the level of achievable ethical consensus, meaning on the national level. And that is what should be proposed at the amendment to the treaties instead of 267 amendments presented by Guy Verhofstadt. Thank you very much.
Sorry, may I add something to what Jerzy mentioned?
Of course.
Because what you described is the very communist method. Every one of us know. That's why we usually say that nowadays we do experience what happened 100 years ago. At that time, they called themselves Bolsheviks. Now they are the Bolshevik. But what is interesting, what you mentioned with your five points of how they take power. I'm sure you remember that Prime Minister Orbán delivered a speech at this year's CPEC Hungary. And he described the 5-point recipe of general recipe of a liberal takeover. First, they redefine normalcy, what is normality. Then they urge the state organs to apply this new or enforce this new definition of normality. Then they declare conservatives, common sense people as some kind of a security risk. Then they do launch the media attack. And then, at the end of the day, they do urge the law enforcement forces, state organs, to take action against conservatives. And sorry for saying this, but what Poland or the Polish right got as a reward what was planned as a punishment for the Hungarian right 2 years ago. At that time, our Ádám Bodnár, a guy called Zoltán Fleck, and other ones from the left, well-known lawyers, well-known law professors, introduced an idea: should the leftist woke opposition win the elections, but not gaining, or without gaining, an absolute majority, what to do? And more or less, according to the recipe of Ádám Bodnár, they said that the rule of law should be just temporarily suspended in order to restore the real rule of law in Hungary. And they planned to change the constitution without a 2/3 supermajority in the parliament. They planned to change every and each cardinal law. Cardinal laws need to be changed or implemented by a 2/3 majority in the Hungarian parliament. And they planned to change those pieces of laws without a 2/3 majority, because they said that this is needed in order to restore the rule of law. And this plan was very openly and publicly published in a very detailed manner. That is what they planned here, but that is what they're executing nowadays in Poland. And those examples, of course, and when this argumentation and papers of the left 2 years ago and 2.5 years ago in Hungary were published, Guess what von der Leyen said? The very same, nothing. So, again, in my eyes, this is a lesson, what we should learn. That, and this is from another speech of Prime Minister Orban from last year's CPEC Hungary, do not play by the liberals' rules. Because if we are trying to, on a legal basis, with legal argumentation, if we are trying to defend the original, the real, the true concept of rule of law here within the European Union, we conservatives, we will lose. They use it as a political tool. I mean, they use the Article 7 procedure and every other, the infringement procedures, the conditionality mechanism, and so on. They use those ones as a political weapon against their political opponents. So it's a political fight. And the right, the conservatives, should use political argumentation as well.
Mr. de la Serna, can we count on your reflections?
Yep. I was, as Miklos Santos was talking, I was remembering two circumstances in Spain that are, we should be careful with this notion of exceptions. Exceptional circumstances, exceptional cases, exceptions to the rule. The first one is the notion that has been advanced in criminal jurisprudence of a vulnerable group. A vulnerable group is a group that should be protected with special measures, with exceptional measures, because they are vulnerable. And we might think, okay, we don't have a legal definition of a vulnerable group. It's a definition that is not coming in the law. It's coming from reports and the so-called gray literature, reports, commissions, and sometimes academic literature as well. And among these groups, you have minorities, which might be obvious, but this is leading to unfair or unjust consequences. For instance, violence against Catholics is not considered a hate crime because the Catholic Church is not a minority. So if you're a Catholic and your buildings are vandalized, for instance, or if your faith is offended, or as a believer you're offended, it's not considered a hate crime because the Catholic Church is not a minority. The same goes to another special circumstance, which is a case of the government's pardon and the amnesty granted to the convicted criminals for the coup d'etat of 2017. The argument goes, this is exceptional. We need to grant them amnesty as an exception because of exceptional circumstances for the sake of social peace and reconciliation and so on, which was a promise that was betrayed in 1978. The promise of reconciliation, the promise of democracy was based in the notion of rule of law. Finally, we're coming to a democratic system where the rule of law will be, as Mario was remembering before, el imperio de la ley, the empire of law. What we're seeing now is that exceptions are the alibi to advance progressive policies. Nothing to do with the rule of law or with the law whatsoever, but with politics.
Thank you. Before we wrap this up, actually we are fighting time here as well.
Fighting the EU.
Fighting the EU and the time as well, but good news that the lunch time is coming. So, but before we wrap this up, we should agree on something, that this European Union rule of law framework is not operable anymore. It wasn't operable from the first time, in my opinion. Well, actually, I would give 2 minutes to wrap this up. Well, please summarize your thoughts about how this rule of law framework is not okay, and how these triple standards that's currently the factual state in the European Union is. Please, Mr. Kwasniewski, start.
what is the core value of European Union, or what should be the core value, is the cooperation and peace. And we have a rule of law becoming a tool of division, a weaponized tool that is employed by some against the others, by majority against the minorities. This crucial core rule and principle of European Union may not be followed. And we become less than we would be if we were alone by being together in European Union. So we need to open this debate on rule of law, maybe taking advantage of the general debate on the amendment of European Union treaties to analyze where to go and what to do with this doctrine that has never been accepted under the treaties.
Mr. Santo?
You know, the debate about rule of law, in reality, it's a debate on democracy. It's much more a debate about democracy than it's about rule of law, because we discussed and touched upon this, that the bureaucrats or the wokist, progressive, leftist elite is trying to use the term and the mechanism of rule of law as some kind of a political weapon. But why? What's the goal? And I think the goal is to outsource every and each decision-making and competence from the local level to the Brussels level, to the federal level, to the international, to the global level, in the name of the universal and absolute value of the rule of law. Each and every day, they invent a new competence which should be in the hands of Brussels without any respect to the existing treaties. For example, they say the Hungarian parliament is not allowed to adopt different pieces of laws in order to protect the children against or from gender ideology, because in the name of universal justice and equal treatment, blah, 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 this is that type of family issue or issue related to minors should be in the hands of Brussels. So the situation, what we're experiencing now, that in the name of rule of law, they are trying to outsource the competencies, the decision-making from the local level, from the hands, and again, sorry that I'm so populist and propagandist, but from the hands of the people. That is why it is a debate really about a debate of democracy. Because if we stick to the true values of the European Union, subsidiarity, for example, or principle of, how do you say it in English, principle of conferral, then most of the decisions, the best decisions are made closer to the people at the local level. Because local representatives, state-level representatives, they do represent the democratic will of the people. If a decision will be made at the higher and the higher level, that will be the distance between the will of the people and the decision or the place where the decision is made will be quite big. So when the Hungarian right or the Polish right or the Spanish right is trying to stop Brussels from overstepping or bypassing their competences that are laid down in the treaties, those sovereignist forces are fighting for democracy in reality. And that is why the Hungarian politics or the Hungarian slogan is about no migration, no gender, no war. Of course, it can be handled as a campaign slogan, But in reality, what we have seen in the past few years that in the name of European values, they are trying to outsource border protection from the local level, and they are trying to implement, let's say, they are trying to manage migration, not to protect the borders, but to manage migration. They are trying to stop every and each attempt from the local level, from the member state level, which try to protect the minors, which try to protect the real family. And last but not least, nowadays we also see that if there is a member state trying to stick to common sense again and trying to argue a pro-peace standpoint if it comes to the war in Ukraine, while saying that Ukraine should have its right to its sovereignty, and the whole situation is because of a hostile Russian aggression, but still Europe's interest would be peace, then again, in the name of rule of law, they withhold the financial funds for Hungary. That was highlighted by von der Leyen in her State of the Union speech. So it's no hidden fact anymore. That's the situation nowadays, I think, and it mirrors that it is a political situation, not a legal one, and political situations usually are decided on election days.
Thank you. Mr. de la Serna, what's your way out from this trap the European Union has navigated into itself?
Well, definitely there is no way out if we accept the framework of the philosophical and cultural framework of wokeism. Let's use the word that was used also by Miklo Santo. I think that first we need to stick to the treaties, which means to stick to the limits of the treaties and to defend the sovereignty of nations. I think also that we need to bring the real meaning of words that we use to interpret law, and it means to recover, to bring back to the conversation the Western tradition, or the Judeo-Christian tradition, or the European tradition, you name it. And I think third, that we need to understand that the discussion about the rule of law is a discussion of democracy, but the discussion of democracy finally is an anthropological discussion on whether we accept or not that there are things like nature, that there are things like human dignity or basic freedoms. And I'm afraid, and again, I'm not representing anyone, this is just my personal opinion, but I think that if we don't take the conversation to this level, sooner or later, there will be something that'll be missing. Thank you.
So, ladies and gentlemen, thank you very much for the attendance of this panel, and I have good news. We are moving on to lunch break. So thank you very much.